I've got a great topic for you today. In the middle of a trial here in New York, if both sides agree to settle the case, can the judge turn around and decide not to accept their settlement offer and force the attorneys to go to trial and complete the trial and take a verdict? You want to know the answer? Come join me on this walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. It is a beautiful, blisteringly hot day today, and I had a few minutes to share this great information with you. The answer is, in all likelihood, no. The judge is not going to be able to force the attorneys to go to a verdict when both sides agree in the middle of trial to try and settle this case. So here's an example. Let's say you bring a lawsuit against your doctor claiming that he was careless and his carelessness caused you harm and injury, right? And now the defense refuses to acknowledge they did anything wrong. Well, that meant you're going to trial. Okay, so now you're in the middle of trial. Witnesses are being questioned. Witnesses are being cross-examined. Evidence is introduced. Testimony is taken. And now in the middle of trial, both sides realize, you know what? We should be settling this case. There are risks on both sides, so each side has agreed to negotiate, and now at some point during the trial, each side has agreed to settle for an amount that's been negotiated. Okay, so now both attorneys approach the judge during a break in the trial and say, Your Honor, at this point we've reached a negotiated settlement, and that's the end of it. We'd like to put the settlement on the record. And the judge says, oh no, not a chance. You brought me this far, you wasted 2 weeks of my time, you think I'm now going to allow you guys to go ahead and settle this case in the middle of the trial and not take a verdict? Not a chance. You're going to continue this case, go to a verdict, and that's the end of it. Can he do that? Well, technically, I don't think he can. You can't force an injured patient and his attorney to go ahead and proceed all the way to verdict, especially when there's been a negotiated settlement. Each side has now come to the conclusion that it is much better to try and settle this case now before a jury ultimately gives them a verdict. The defense recognizes that there is a risk a jury could come back and give them significantly more than what they're willing to negotiate for and settle this case for. The injured patient recognizes that there is a risk that if they go to a verdict, the jury could come back and give them nothing or a lot less than what's being offered. In that instance, both sides realize it's much better to try and settle this case now rather than take the risk of letting a jury decide who's right and who's wrong. In that instance, now they approach the judge. Judge, we've reached a settlement in this case. We now would like to put the settlement on the record to confirm exactly what we agreed to. And the judge turns around and says, oh, no, you don't. I want to see the end. I want to see what a jury's going to do. No, in all likelihood, that's not going to happen, Judge. Why? Because you can't force a litigant to continue on with their case if they've reached an out-of-court settlement, or even if they've reached an in-court settlement. You're not going to be able to force the litigants to do that. And if the judge somehow forced the attorneys to continue, I think both sides would now have an appealable issue. So no matter who won, who lost, both sides would probably appeal and argue to the higher court, to the appellate court, judges, listen, this judge made us do something that we didn't want to do. Neither one of us wanted to take a verdict, and now we're stuck with a verdict that neither one of us wanted. We wanted to end this case before we ever got to a verdict. And it's only because of this judge's improper actions that now we're forced to appeal this issue. Not one of us, but both of us are appealing this issue. And because of that, we ask you to instead enforce the settlement that we had agreed to before taking a verdict. How crazy is that? Well, thankfully, in over 30 years of practice, I have not seen that issue come up. But I'm thinking in my mind, how crazy would that be if, in fact, that did happen? You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit, but are thinking of doing so and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions just like yours, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.